Sure, abuti honestly.
No, thank you very much for all the questions. Maybe start with the last one. It's true that NSFAS indicated to us that the reason why they were not paying, it's because they were verifying where a number of things. One, if the accommodation provider or providers were accredited through their own process. You'll remember there's two processes. There's what do you call it? Accommodation providers are accredited, one through the NSFAS process, that one that they called a pilot. Then you have one that is accredited by universities. So NSFAS pays about 4 middlemen to do this accreditation for them. There's about 4 companies that we call them middlemen because, I mean, why would you want to go and verify? It means you are saying you don't trust the reports that are coming from these people that you are paying. That is the first thing. So they said they are going to verify that process. But that process you can't verify forever. NSFAS must come through. In fact, members would have said to us, we must call them before the end of June. We must call NSFAS before the end of June. But unfortunately, because of this budget process, we can't change anything on our calendar now. But as soon as we get a day, they will have to come and respond to us. We're happy that they are saying they are going to provinces to verify this and that. That's good. But that can't take forever. That's what they would have said to us. You'll remember that members were not happy again with the quality of work of this, they call them solution partners, that these solution partners are doing. Somebody was joking in the meeting saying, these people are supposed to be called solution partners, but they are not providing any solutions. So they must be called non-solution partners. So these solution partners, somebody was saying we must call them as well, because there's a lot of problems that are attributed to individual providers, these solution partners. Some of them, the allegation that NSFAS would have released some of the money to them to pay accommodation providers, but they were keeping the money in their accounts to accrue interest and not pay these accommodation providers. Others were saying accommodation providers would have submitted invoices to them. They must submit invoices to NSFAS. NSFAS must pay these invoices to these solution partners. These solution partners must pay to NSFAS. So if NSFAS is able to pay these solution partners, what makes it difficult for NSFAS to receive this, because they are receiving invoices. They just receive it from somebody in between. They receive invoices and they're paying those invoices. So what makes it difficult for NSFAS to receive an invoice directly from an accommodation provider and pay directly? Because that's what literally has been done, but it's been done through a middleman. News 24, we have indeed, the committee resolved that we must write to all panelists. I wrote to them on Thursday morning. I've given them till Wednesday, the 25th of June, to give us written responses to questions that we have given. They must tell us when were they approached, did they receive correspondence through letters, and all of the terms of reference, all those kind of things. So because we don't have a date for us to meet with them as yet, we then ask them to give us written responses to, everything that we have asked them about the appointment, the number of meetings they've had, all those kind of things, including Advocate Terry Mota, we have written to him. None of them, we've given the deadline is on Wednesday, so none of them has written back to us. That is not strange. When you say somebody write to us by this day, most often than not, they do write to you on the last day. So they've not written to us. I've not looked at my emails today, but I've not seen anything. We're expecting them to write to us by end of business on Wednesday. What consequence management for the minister? So the committee was deliberating on whether we should activate Section 17, subsection 2 of the Powers, Privileges and Immunities Act, which speaks about the consequence management should anyone come to Parliament and mislead Parliament or to give Parliament inaccurate responses. We deliberated on that and we said we will obviously ask legal to help us there, but can we say that the minister would have misled us? Or we must bring her to the committee to clarify what she said on the meeting of the 30th of April and the letter that she sent to us on the 17th of June. So we then resolved that we will bring her. That is why we're looking for the date. So it's not conclusive whether she has lied or not as at this point. I mean, those who would have studied law, they would tell you that the constitution of, even when we have seen somebody kill that particular, if a cop, an SAPS person sees you shoot somebody, in court you'll still be referred to as a suspect, even though, and we must still, the state must still prove that you shot that particular person. So this is not something that we take lightly, but we're not going to jump any stages. We're going to follow all processes. So there's it's also not right to speak about if you find that she lied, what would happen? But I'm sure you know, we've clarified in the letter that we are empowered, by the way, by the Constitution, firstly, of this country, Section 55, that tells us that we must hold the ministers or the executive and all national departments and all national entities under that department accountable. Section 227 of the National Assembly rules also gives us those particular powers to do so. So we are going to do what we must in holding everybody accountable. And then EWN, clarity on concealing of names. I think, so on the letter that the minister wrote, there's a blanked parts, or there are blanked parts. You see, I'm very happy you have not seen it because it means my members have not leaked it because I shared it with them. It means we're getting somewhere. But there are blanked parts, and therefore some members felt that it means the minister would have concealed some names there, and we must ask her to release those names. So we don't know whether it's because they were indeed concealed, or it's because there were spaces there and therefore they were blocking it so that you guys with AI don't include other names there. Because you know, with this thing of deep fake and artificial intelligence, people are very creative. So we don't know. So what I've done, I've written to the minister again, giving her until Wednesday to clarify whether she did conceal. She must explain really what is the format there. Whether she concealed names, and if she has concealed, she must release those names. Or if she did not, she must then explain what would have happened there. So unfortunately, when we speak on behalf, even on behalf of issues of that members would have raised. So in our statement, we had to raise it because it was raised in the portfolio committee, but we have written to the minister. We're waiting for her to respond to us by Wednesday this week. I'm not sure if there's anything that I've left, but I think we've covered everything. Thanks.
Yes, just before maybe I move to the next chairperson for response, I think there is one question for you on the virtual platform. What is it's from Gwena Mashalo from Sowetan. What is the status of the legal suit with the University of Limpopo? Also, what steps has the minister taken against the registration crisis at the University of Limpopo?
No, thank you very much to Sowetan. The issue of Limpopo, it gives me a headache because they had promised to sue me personally. Wrote me 2 letters. Maybe they've lost my email now, or their lawyers have lost my email because I've not received any more threats from them. So with the University of Limpopo, let me, on the status of our issues with the University of Limpopo, let me start like this. So the committee on the 5th of February resolved to summon University of Limpopo after we had written to them a number of times, requesting information from them that they had promised to give us in the meeting of the 20th of November, 2024. And they did not respond. So on the 28th of March, 2025, the sheriff hired by Parliament delivered the summons to University of Limpopo premises. So they received the sheriff's notice at around 10:25 a.m. University of Limpopo did not respond to our summons. And around the 9th of April, I wrote to the speaker to find out if they had responded because we want the next step. The next step would be to open criminal cases against them for not adhering to a court process of summons. Then University of Limpopo circulated a letter dated the 4th of April 2025. In the letter, they were claiming that they had, the sheriff came to Parliament on the 4th to deliver, and because they had emailed it, somebody in the office of the Secretary to Parliament told them there's no need for the sheriff to deliver the letters, what do you call it, the response to the summons. You know, when you arrive there, all of you who are here, you know, when you arrive in Parliament, you go to the visitor center. Everybody who does not have an access card goes to the visitor center. So there's no one who can claim they've been to Parliament and they've not been seen by there by the visitor center. Secondly, I met with the Secretary to Parliament because this letter was doing the rounds on social media, dated the 4th of, was claiming that the email was sent to the Secretary of Parliament or Secretary to Parliament. So we met, the Secretary to Parliament did not have that email. So in essence, those of you who followed that story, the University of Limpopo spokesperson went to all of you who are media, print, broadcast, everybody, literally lying to South Africans that they have submitted the summons, or they've responded to the summons. So what was then discussed in that meeting was, what do we do? And I said to them, to show that we're not personal with those people, we just want our answers. We will reissue, or we will take the matter back to the committee for us to reissue, with a view to reissue the summons. We took the matter back to the committee. The committee deliberated, voted on the matter. Majority said, we can't have a situation where our institutions that we fund with so much money. I mean, well, on the 3rd of July, we're going to vote for budget vote 17. In grants alone, universities in this country will be giving them about 48 billion rands now on the 3rd of July. And for them to behave as if they report somewhere and not, literally to disrespect Section 55 of the Constitution of South Africa, Section 227 of the National Assembly rules, is not something that we're going to take lightly. So we have written to legal to reissue the summons. That meeting of the 30th voted on the matter, and I hope tomorrow those people are not going to make it a Tebogo versus University of Limpopo, because that's what they did the last time. I'm just a spokesperson that Moloto, just like you are the spokesperson of Parliament. If Parliament communicates, you must communicate. I communicate on behalf of the committee. They must not make it a Tebogo issue versus University of Limpopo. I've got no quarrels with, I don't know those people. I mean, they must just answer the issues that we have asked them, including how they would have spent about 13.7 million rands in 1 year in 2023, pursuing students and workers. We want those answers, because it can't be that universities spend so much money on students and workers. And the second question on the registration issues, you'd understand that in that meeting, the committee would have told them that there seems to be a problem with understanding the national qualification framework from the university, because we were receiving a number of emails coming from students, and some of them might not be writing to us, not because they don't have issues, but because they don't know the recourse to follow. But the university there was, at the time, embroiled in a court battles with two students, Pelisiwe Cele and Tandom Guni, who were finishing their master's degrees 2 months before they are supposed to graduate. A university deregistered them after they would have been registered for 2 years, after they would have done the work, paid school fees, used their last resources to complete that particular thing. And when you inquire, why are you deregistering them 2 months before graduation? The university would have literally said it's an NQF level issue that they were following. But if you go to the only legislated agency in South Africa that can speak with authority on the qualification framework, which is SAQA, South African Qualifications Authority, they will tell you that the university there is wrong. And when the committee is saying, you seem not to understand this national qualification, because a student who does, what do you call it, advanced diploma, gets NQF level 7. This is in a university of technology. You've got advanced diplomas, Previously, they used to call them something I forgot, but they were changed to advanced diplomas. That's NQF level 7. It's equivalent to somebody who gets a degree. It's advanced diploma, NQF level 7, degree, LQ level 7. So this is the case with these two students. They would have went to DUT, completed this, and then went to UKZN to do their honors NQF level 8. So they were accepted by this institution, University of Limpopo, for a master's NQF level 9, on the basis that they had this honors degrees from University of KwaZulu-Natal. As we told them they're going to lose, they're wasting money. They went to court, and around March, February this year, as expected, they lost that case. In fact, if you read the judgment there, it's I'm very happy with that judge. That judge was very clear. I think it was 9.1 on the judgment where he says the decision to review and the decision not to confer this student with their masters is reviewed and set aside. That is number one. Those of you who studied law, they will tell you that what the judge they say, saying everything that you have argued about you being right as an institution not to give the student their degree is literally hogwash. It's set aside. You have not argued correctly. So that decision is reviewed and set aside. That is the decision. Number two, he says, I'm instructing you, because the judge can't, we're constitutional democrats, can't go around, our courts can't go around giving people degrees. We've got senates at universities that are responsible for that, because here we're guided by the Constitution. He says, let your senate go and redetermine this decision. What does that mean? It says you are determined that you're not going to give, but I'm instructing you to go and review that particular decision. He does not stop there. He goes and says, I'm slapping you with costs. Why? Because you have wasted the court's time. You did not have a case here. So that's what the judge said. But if those of you who followed that case, their spokesperson there was running around here saying the judge did not say they must give those students degrees. I don't know. Those of you who are lawyers, maybe let's assist each other. Let's assist that institution to also, because they seem not to have a legal department that must help them. Because for us, it's a simple thing to do. So we have asked the minister in December to look at the administration and governance collapse at that institution. So there are many issues there. I mean, the chairperson of council there is there in the third term against the university statute, or university constitution that guides them. The vice chancellor there, we don't know how many years he has been there. We asked them in the meeting, VC, how long have you been a VC? He himself did not know. That's how long he's been there. It's been sometimes it's 2 terms because it's one university. Sometimes it's more because it started at University of the North. If you ask him how many terms, he did not answer us in that particular meeting. So which is against the university statute that says a maximum of 2 terms. They claimed to have had a legal opinion that says it's not supposed to be 2 terms, but we said, no problem, you must give it to us. We're still waiting. Those are the documents that we are still waiting for them to give to us. So the minister has been given until the 30th of June to come present to the committee if she will be appointing an independent assessor, and if not, why not? Given what the notes or the evidence that the committee members would have given them. I mean, the Director General, when we read him the judgment of these 2 students, they were surprised. He said, please send it to us. And members were saying to us, on the 20th of May, you went the DG with the minister to University of Limpopo, and the clips that we saw there, you said the university is stable. What's stable when you don't know this information? So members, again, last week we told the department that law firm that lost the case with these two students, they are in court again, University of Limpopo. They are going to be in court for a long time. They are in court again for refusing to confer. Another student who have taken them to court again. And what surprises us is that University of Limpopo has appointed the same firm that lost with cost, the same firm to represent them on a similar case. And when people write to us and say, you must check how these law firms are appointed at that institution, you must check their relationship with the leadership of that institution. And you must, we have asked them to give us a breakdown of 2023 alone, which law firms represented at which case in a table format, how much did that cost, and what was the case about? Was it against student, workers, or service providers, and what was the outcome? Because people would have written to us and said to us, if you look at that, you are going to see what some of us, the old school, will call Lisilo ruler. We're going to see Spoke because it's very scary there. Thank you very much. I hope I've responded. Thanks.
Sure, I would do ownership.